right, welcome back. We've seen now patents and trade secrets. Now I want to talk about trademarks. And trademarks originate in the common law. But in 1948, Congress federalized trademark law when Congress enacted the so-called Lanham Act. Lanham, one word. The Lanham Act is a federal trademark law. Now, what's interesting about trademark law is it's very similar to trade secrets. You don't have to have a formal registration in order to have legal rights to your marks. But as I will explain momentarily, federal registration, if you are in commerce, if you're selling a product or service, it is and your business is growing, there's demand for your product or service, federal registration really is highly recommended. But first of all, how do you create a trademark? One of the interesting things about trademark law that makes it unique is that you have to be in business, or you have to already be in commerce. You have to be offering whatever it is, whatever product or service that you want to trademark, that you want to brand. You have to be, it's kind of a catch-22 or chicken and egg. You have to be offering that to the public. You have to be somewhere, in business or in commerce. Now, trademark law does allow you to file what's called an intent to use. If you are maybe within the next 6 months about to launch your product or launch your service, then you can file an intent to use trademark application or trademark registration. But then you do have to go into business, go in commerce within those 180-day period. Bottom line is for federal, and this is true for common law as well. Common law rights, as long as you're selling a good or offering a service in commerce, and you are distinguishing that good or that service with a mark, you have a common law right. Now, registration, now how do you get the common law right? And here's where federal law clarifies what the common law established. There are different types of marks. If the description of your product or service is generic, let's say you're selling coffee tables and you want to call yourself the table company. It's going to be very hard to get a trademark on, because it's just a generic description. You cannot, in essence, trademark words that are already in the dictionary. Is sort of a common rule of thumb. Now we'll look at something called genericide a little bit later, when you actually have a term that is already trademarked, but it could become such in common use that it becomes just generic. But let's just, that's rare. It does occur, but let's focus on the main category. There's generic marks. There's also descriptive marks. Descriptive marks are very similar to generic marks. They're just describing the product or service that's being offered. But descriptive marks, courts will allow you to trademark a descriptive mark if, and this is the legal test, if there is a secondary meaning in the minds of most consumers as to what that mark refers to. I'll give you a great example, American Airlines. So American Airlines, right, literally is a North American commercial aviation company based out of Dallas, Texas, if I'm not mistaken, right? Or Southwest Airlines, right, began as a regional aviation company literally in the Southwest. But today, in the minds of consumers, right, when you hear the word Southwest Airlines, you're immediately thinking of the Southwest Airlines, where there's no assigned seats. You just, you have the different boarding sections, and, they have their ways of doing, no frills, right? They were the original no frills airline. With American Airlines, again, you're thinking of not just any North American airline company, but you're thinking of the iconic, American Airlines with the silver fuselage, and the red, white, and blue trim, right? You're thinking of the company American Airlines. So there's a secondary meaning, even though those terms are descriptive. The next type of mark that generally does get protection with or without secondary meaning is going to be suggestive marks. A great example of a suggestive mark is copper tone, right? Copper tone skin sunscreen products, right? The idea that you want to get a bronze tan, and copper tone will help you get that tan. So it's just suggesting what the product does, not in a literal or descriptive or generic way, but suggestively. Lots of marks are oftentimes end up being suggestive. But the fourth and final category of trademarks, and these are considered the strongest marks and the easiest to obtain trademark registration for, are so-called arbitrary or fanciful marks. Now, arbitrary or fanciful marks, they're kind of lumped together. Best example here might be, I would say, Exxon, right? Or Chevron. Some of these petroleum companies, right? Energy companies, right? Google actually is a great example of an arbitrary mark, right? Google, just a made-up word. It's fanciful, right? And the word Google really has nothing to do with search engines per se and search of information. There is a mathematical concept called a Google, but it's spelled different, Googol, which is what Google, the trademark brand, is a play on words of. Google, the mathematical concept, refers to a one with, I think, a billion zeros, or it's just an astronomically large number, right? And so the idea of Google is internet, right, is pretty much astronomical, all the information that's out there, and Google will help you organize it. But it's completely arbitrary and fanciful mark. Kodak, back in the day, before Google, Kodak was a huge company. I understand they're coming back, a huge film company, right? Kodak, really nothing to do with film. Today, of course, we associate it with film, which raises a question. When does even an arbitrary or trademark could eventually become generic? That's something we'll do in our next case, Google v. Elliott. Do you think that Google has, is it already a generic mark? Well, that was precisely the issue in this case, Google v. Elliott, which is in the latest edition of the textbook. I'll talk about that case in my next video.